Hi, good evening, everyone. Welcome to the second session of Legal Sprint. And so, as we had, discussed in last class, first of all, we discussed. So, I'll just have a quick recap of what we did in the first session. So, in the first session, we actually, revised the syllabus a little bit. We understood that what are the type of questions which they're asking. We also discussed some of the important topics or the news which are in, the those important topics which can form part of your paper. And as I had discussed with you guys, and I asked basically from you guys what I shall be covering in this session. So some of you also asked, so that day I couldn't see the chat box, so today have opened it in my phone so that I can also look at your questions which you are posting in chat box, because I am taking the session through Zoom and you guys are typing on YouTube. Yeah. So the first thing which I when I was going through the chat once the session ended, some of you had asked questions with respect to the type of options where you get confused. Like if you look at certain options, there are two or three options, two options basically, which seems to be correct one. So there you get stuck as to which option is the most suitable one and where you shall go ahead with which of the option. How you shall be eliminating in the case when two options are close one. So, with respect to that, what I would suggest is whenever we answer a question, the first and foremost thing which we have to look into is which option is very much closely related to what has been asked in the question or what the fact has is stating. Secondly, the options are exactly having the wordings of the passage, or for that matter, if question is asking about certain laws, and that is something which has been discussed in the option, then obviously I'll be going ahead with the that option which is having exactly the wording of the questions, or maybe having exactly the principle which is mentioned in the passage, or maybe is explaining in detail what the question is asking from us. So this was one question which I think I wanted to address. Second, again, as I had discussed with you guys, so there are two parts in which I would be taking today's session. One is I'll be discussing two or three passages where you guys are supposed to write the answers in the chat box, and accordingly I'll be explaining you that whether the answer is correct or not, how you shall go about answering the question. Although I'm very much sure that by now you guys have already mastered the art of answering the questions, or you are already in a good position in scoring above 25 in legal section. But then also we'll take two or three passages, and then we'll move to current affairs aspect. So maybe in today's session I'll cover 5-6 topics from month of September and August, which is important from your examination perspective. And then if in the next session, we'll cover the entire current affairs. So moving ahead with the passage discussion. So I'll share the screen and I'll show you the passage. You guys are just supposed to have a quick read of the passage. I hope the screen is clearly visible to you guys. You guys can see the questions. So I mean the passage over your screen. You can type in the chat box. Okay, before that, there's a question. I'm getting average marks of 20. Is that good or bad? Actually, 20, if you're talking about legal section, so it's not really bad also, but I can't tell or say that it's really good also. So maybe from 20, we can think of, improving by 5 marks. So if you are in a position of scoring 25, then that's really good out of 30 or 32, whichever option they go ahead with. So that will be a fair good enough score. So try to improve little bit and try to increase your marks by 5 at least, and 20 is not that bad score also. Okay, yeah. Coming back to the passage. So basically, this sheet I have picked up from the passages I have picked from is CLAT 2020 paper. In last class also I had stated and I had asked you guys to go back and solve past year paper if you haven't solved it yet. So coming to this passage is basically talking about obscenity. So as we had discussed in the last class also when we were covering syllabus, that this is something which they have already mentioned, that we would be asking questions from morality aspect also. This passage basically I picked from that perspective only, because I just wanted to explain to you guys that what are the morality aspect which they are focusing on. Just give me a second, I need to erase this. Entire passage got highlighted. 1 second. Okay, anyways, so the passage, 1 second. Okay, sorry. Anyways, it's not happening. So we'll directly move to the passage. We'll discuss that only. So the passage is talking about obscenity, that the issue of obscenity has vexed the courts in India and abroad for a long time now. And this is something which is covering your moral aspect also, and this is something which is covering your legal aspect as well. Then this passage is basically highlighting the Hicklin test, which actually defines what is the test of obscenity. So it says the test of obscenity is whether the tendency of matter charged as obscenity is to deprave and corrupt those whose minds are open to such immoral influences and into whose hands a publication of this sort may fall. Hicklin tests postulate that a publication has to be judged for obscenity based on isolated passages of a work considered out of context and judged by their apparent influence on most susceptible readers such as children and weak adult minds. However, now the passage is saying that this is something which was a test of 1868, which was let down, which actually, classified, or which actually stated that how obscenity is being taken into consideration. Then now the passage is also talking about that it has to be judged in contemporary social mores, current social moral attitude of the community and prevalent norms of what is being accepted in the society. Then it is also explaining the Ranjit Udesi's case and the other cases which is mentioned over here. And then it is now saying concept of obscenity would change with the passage of time. So this is something which I think I had highlighted in last class also, that when we were talking about the regulation of OTT platforms, so there I had clearly mentioned that what may be obscene for you may not be obscene for me. Similarly, what may be obscene for my parents or our parents, so now the time has changed, scenario has changed, it may not be obscene for me. So considering that, it is now stating that now it obscene at one point of time would not be considered as obscene at a later period. This came to be known as community standard test. So basically, this passage is highlighting two aspects. One is Hicklin test, and the second one is community test, which says that complete message and context has to be taken out. You cannot take the matter as an isolated matter, but you actually have to figure out what the idea behind the entire thing is, and whether this falls under the category of obscenity or not. So here goes the first question. I'll give you a time of let's say 1 minute to go through the question and answer it. You can write the answer in chat box. The question says a daily newspaper, local newspaper called Ramanand Bazar Patrika, having wide circulation in Anand Nagar, published on 1st July 2019 an article with a picture of Boris Becker, a world renowned tennis player, posing nude with his dark skinned fiancée by name Barbara Felters, a film actress, which was photographed by none other than her father. The article stated that in an interview, both Boris Becker and Barbara spoke freely about their engagement, their lives, and future plans, and the message they wanted to convey to the people at large for posing to such a photograph. Article picturizes Boris as a student protesters of the pernicious practices of apartheid. Further, it was stated that the purpose of this photograph was also to signify that love champions over hatred. Will the Ellis picture classify as an obscene material in India? A, no, according to Hicklin test, it will not classify as obscene. So the first one is talking about Hicklin test. It is saying that it won't be classified as obscene. Second says, yes, according to the community standard, the picture will classify as obscene. Third says, no, according to the community standard test, the picture will not classify as obscene. D, both A and C. So this is talking about the current scenario, and current scenario is focusing on community standard or test. Okay, Yash has mentioned C as an answer. Devansh has also mentioned C. Vijay has mentioned B. So when you talk about B, Vijay, which is talking about community standard test, it is talking about we have to look into the message. We have to look into the context of what they are trying to classify or what they are trying to convey. And here, when you look at the purpose was also to signify that love champions over hatred. So there was a message which they wanted actually to convey. And that message was that, love is something which is bigger than hatred. So keeping that in mind, the context, the message is something which cannot be considered as an obscene one. So keeping that in mind, I'll go ahead with choice C. So again, the answer is some of you, three of you went ahead with C, two of you went ahead with B, and one went ahead with D. How can you say that it is D? Acha, you are applying both Hicklin test and community standard test. But Hicklin test is something which is the older one. Right now, we are going ahead with the community standard test. So actually looking into the current scenario. So keeping that in mind, option D would be the right choice. Sorry, option C would be the right choice. Yes. Now moving to the second question. I hope screen is clear to you guys. So the second question is asking about the difference between Hicklin test and community standard test. ये तो फटाफट करना है आंसर because already मैंने बता दिया है कि दोनों टेस्ट क्या होते हैं. Vijay, I'll come to your question at last. So the difference between Hicklin test and community standard test is the former focuses on the susceptibility. Yeah. The former focuses on susceptibility of the minds of individual to get corrupted, while the latter hinges upon the context, intended meaning, and contemporaneous social culture environment of the society. Okay. B says, as per Hicklin test, a nude picture of a woman per se can be obscene, while as per the letter, the picture should be suggestive of depraved mind and designed to excite sexual passion in a person who are likely to see. This is not correct. So B to already will overrule. C says the former consider obscenity as a changing concept with changing times, while the latter does not. This is again the ulta of what is being discussed over here. So by elimination rule, since B, C got eliminated, D also got eliminated. So we are left with choice A as the right answer. So Yash Nautiyal and Yash Kumar both have marked it correctly. It's option A, the right choice. Moving to third question. The question says the issue of obscenity is fundamentally related with which of the following? Freedom of religion of an individual, freedom of speech and expression of an individual, right to privacy of an individual, D, all of the above. Okay, before this, again, I would want to go back to the passage. Just give me a second, guys. Okay, yes. Option C. Sorry, option 3, answer. Question 3, answer. Before I answer this question, I have a question from you guys. Can you find something in the passage with respect to fundamental rights being discussed over there? I'm seeing your answers, but at the same time, I'm also, I think, okay, my question was, guys, is there anything being discussed about fundamental right in the passage? You all have read the passage just now. Everybody's saying answer C as the right choice. Uh, I don't know. I think when I speak on Zoom and when it goes on YouTube, there is a lag of some, 30 seconds or something like that. Okay, meanwhile, you guys will type the answer related to privacy, ma'am. Arya is saying, okay, the issue of obscenity is fundamentally related with which of the following? Okay, so Arya is saying it is related to privacy, ma'am. So option C is the right choice. Okay, most of you went ahead with choice C. Two, Anandi has mentioned B, Devansh has mentioned B, and I think rest everybody went ahead with choice C. So when we talk about obscenity, now I'll take you guys back to question number 1. So question number 1 में क्या था? The person posted something on, I mean, it was published in newspaper. So he had a right of freedom of speech and expression, and that's why he published it. Now it is up to you guys how you are looking at that particular content. For example, again, I'll go back to the last session. In the last session, we were talking about, when we were discussing the morality aspect, we were talking about Oh My God movie, where I stated that this is something which is not being shown to child, although the movie is based on a children between the age group of maybe 12 to 18 or 13 to 18. So in that scenario, here it is about freedom of speech and expression. When you are expressing something, whether that expression will be taken in society as an obscene expression, or people will basically look it at from the perspective or the message which a person tries to deliver. So keeping that in mind, it has nothing to do with right to privacy of an individual. This is article 21, which is nowhere mentioned. We will be going ahead with choice B, that is freedom of speech and expression of an individual. And why I was asking this question, that whether it is being discussed in passage or not, is because this is something, all these three things has not been discussed. Here we are applying our extra legal knowledge. So basically, wherever you have an option of going beyond, please don't hesitate, as I have stated in last class also. Now, coming back to question number 4, which says, consider the following situations, choose the correct option as per Hicklin test. A movie scene where there are rows of Jewish naked men and women shown frontally being led into the gas chambers of Nazis concentration camp. Not only they are about to die, but they are stripped of their basic dignity in the last moment of their life. Recently there was a movie in which this was basically shown. I think that movie was remake of some English movie. Varun Dhawan was part of that movie, if I'm not wrong. Second says the controversial movie scenes of Phulan Devi, the bandit queen, where she is paraded naked and made to draw water from the well within the circle of 100 men. So what would be the answer of this? A is, one is option, but two is not. B, two is, but one is not. C, both one and two are option. D, neither one and two are obscene. Here you have to apply the Hicklin test, not the community standard test. Hicklin test apply करना है. So here, as per the Hicklin test, which we are looking into a isolated situation, and from where what we are considering, here we'll go ahead with choice C, that both 1 and 2 are obscene. So keeping that in mind, option C would be the right choice. Maybe अगर हमें community standard test लगाना होता, तो in that scenario we would have stated कि one is to something which is depicting actually the situations which were there in Nazis concentration camp, and it is actually showing us the history. So in that scenario we would not have considered it as an obscene thing. But since we are supposed to apply the Hicklin one, option C is the right choice. Now moving to question number 5. An activist, while being semi-nude, allowed her body to be used as a canvas to paint on by her two minor children who were properly clothed. She uploaded this video of hers on an online platform with a message that she intended to normalize the female form for her children and not allow distorted ideas about sexuality to pervade their mind. An advocate who sees the video registered a case of obscenity against her. Is it a case of obscenity as per the community standard test? So here we have to apply the latest one, the community standard test. This is a pure case of obscenity and she is spreading it. B, this is a pure case of obscenity as well as child pornography as her children were exposed to her nudity. This is not a case of obscenity because as per the community standard test, the video must not be seen in isolation, but in the contextual setup of a message that the activist has put on normalization of a female sexuality. And D, this is a case of obscenity as per the community standard test, as the video was blatantly obscene. Yes, Tanish, you are right. So in this case, again, so wherever, all the three options, A, B, and D is saying it is obscenity as per the community standard test. But C is the one which is, explaining that this is not a case of obscenity because here we are not supposed to look at it in an isolation format, but we actually have to figure out what is the message which she is trying to convey. So in this case, option C is the right choice, that this is the where the message is basically to make sure that the children does not consider women as an object but respect women for what women is. So this was actually based on an actual case law which was there in news, and that's why this came in your paper. So this is here option C would be the right choice. Now moving back to passage 2, just have a okay. So before we, I would not be giving you time to read the passage because we all know what is polluter pays principle. So polluter pays principle basically says कि आपने pollution फैलाया है तो आप उसको pay करोगे. This is your liability. This is basically well established principle of environmental law which places an obligation of compensating the damage to the people who out to reimburse it and also have the capacity to disburse it. So the person who damages or destruct the environment has the absolute obligation to bear the cost. So this is basically what is the polluter pays principle says. Now second one is talking about principle of strict liability. So you guys very much know what is principle of strict liability and principle of absolute liability. Strict liability, the law came into Rellan and versus Fletcher case where it was stated that if you are doing something at your land which is a which is a non-natural use of land, and here if the thing escapes out of your land and results in some damage to the other person, then you are liable to pay compensation. And in case of strict liability, there are certain exceptions which can be used. This is there. In case of absolute liability, obviously, Supreme Court of India laid down this principle in MC Mehta versus Union of India. MC Mehta versus Union of India, basically, there were two cases where court was, taking this into consideration. One was obviously Bhopal gas tragedy case, and the second one was Sri Ram fertilizers case. So in both the cases, court basically discussed about or laid down the, for the first time, it was laid down or stated in Sri Ram fertilizers case, which is also known as MC Mehta, and it was applied in the case of Bhopal gas tragedy. So here the Supreme Court stated that now we have moved into a new era where we are technologically very much advanced, where we have all the capacity to prevent such harms. And if because of us, if we are dealing with something which is hazardous in nature and it causes some harm to the public, so in that case you are absolutely liable for your conduct and you cannot cannot take any defense which is there in case of strict liability. So absolutely liability means there cannot be any defense which a person can get in case of absolute liability. And you all know the consequences of Bhopal gas tragedy. Still people of, I mean, the people who are born in that particular area, they are having some health issues because of this, Bhopal gas tragedy incident. So, and why this case passage was asked in 2020 paper, because at that time, if you guys remember, there was this Vizag gas leak which has happened during COVID time, and since it was in news, and where NGT, which is National Green Tribunal, which generally looks after the matter of environmental issues, NGT stated that this is a case of strict liability, and there was lots of debate and discussion that how come NGT stated that to be as to be a case of strict liability, and why not a case of absolute liability. Later on, it was stated that the Vizag gas leak falls into the category of absolute liability. Now, coming back to question number 7, which says, as per the polluter pays principle, LG Polymer will be liable to pay amount of money for restoration of environment, amount of money for restoration of environment, and compensation to individual who suffered the loss, compensation to the victim, D, none of the above. So I'll just wait for your answer and then we'll move ahead. So question is asking about the polluter pays principle, and polluter pays principle says that person who damages is or destructs the environment has the absolute obligation to bear the cost of ameliorating the environment. And court held that polluter is largely legally responsible to reimburse the individual sufferers as well as pay for the revitalization of the damaged environment. So in this case, here we will go ahead with choice B, amount of money for restoration of environment and compensation to individual who had suffered the loss. This is very much clearly explained in Enviro Legal Action versus Union of India. Here I'll come back to Devansh, who is uh how come you are saying it's oh, sorry, I moved ahead with question number 7. I missed question number 6. Okay, I'll come back to question number 6 also. Yes, in question number 7 is choice B. Under before that, question number 6, under which of the following principle will the company LG Polymer be liable? Polluter pays, strict liability, absolute liability. In case में तो सब कुछ आ जाएगा, तो option D, Devansh, you were right. Now moving back to question number 8. A company ABC Limited operates an industrial chemical plant in the city of Azad Nagar. Due to an earthquake on July 2020, uh, uh, 22nd July 2020, the valves of the reactors in the plant get damaged, due to which the operators could not properly transport the hazardous gas for chemical vaporization, resulting in gas leakage. The gas leakage resulted in the death of 12 workers of the plant and also some people living nearby the plant. In this situation, in order to decipher the liability of ABC Limited, choose the best option. Okay, so here people are going ahead with D option as the right choice. Okay. ABC Limited can be held liable under the principle of strict liability and absolute liability and polluter pays principle as well. B says ABC Limited can be held liable under the polluter pays principle and principle of absolute liability, but can be exempted under the rule of strict liability. Okay. C says ABC will not be limited will not be held liable under any of the principle. This gets clearly overruled. D says ABC Limited will be held liable under strict and absolute liability principle, but the principle of polluter pays will not be applicable to this situation. So Ashley, Anandi, Arushi, Arya, everybody is going ahead with choice D. Why it's D and why not it's B? Devansh has stated B. Why it's B, Devansh? Can you explain it? How come you guys are saying it's a strict liability? Earthquake आया, earthquake act of God हो गया, act of God हो गया तो exceptions में आ गए ना. An exception principle of strict liability, act of God is an exception which is clearly mentioned over here. The escape is due to an act of stranger, the act of God, for example, a natural calamity due to the person injured. So keeping that in mind, option of strict liability तो ऐसे ही overrule हो गया. और strict liability अगर overrule हो गया तो option D तो चला ही गया ना, which is talking about the person will be held liable under strict one. So keeping that in mind, choice B would be the right answer and not A, C and D. Okay, moving to question number 9. फटाफट इस passage को करो so that we can move to current affairs part. Yes, Devanshu, you were right. No, 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 no. We don't look, Arsh, at the intensity of the calamity to determine act of God. If the action, so we all know that, when there's a case of strict liability, since all the exceptions are there and which can be taken by a person, for example, principal, the wrongdoer, or for that matter, act of God is there, or for that matter, inevitable accident is also there. So in such scenario, not in inevitable accident, act of God, and let's say take into consideration the act of a plaintiff. So in such scenario, they have all the exceptions. So keeping that in mind, the person can always take the exception of earthquake. So we can't hold them liable under strict liability. No, Ashley, it won't be counted. Okay, the argument of LG polymers that they did not know that stearin gas could leak is a strong argument and can reduce their liability under polluter pays principle, is a strong argument and can reduce the liability. It's a weak argument and will not help in reducing the liability under any of the principle. Is a weak argument but may help in reducing their liability under the strict liability principle. Again, it's very simple. It's a weak argument because if you are dealing with an hazardous substance, you will be held liable and it is devoid of any exception. So keeping that in mind, option C would be the right choice. Arya, which is not a reason what you're saying. Can you write it properly? Okay, weak argument. Okay, perfectly fine. Moving to question number 10. Last question and then we'll move to current affairs. XYZ is a company operating a pesticides factory in the city of Rampur. On one day, due to the negligence of factory staff, there's a leakage of pesticide gas, as a result of which many pests and insects which feeds on the plantation crops in the nearby farms are killed. There is no harm caused to the people living nearby or the workers of the pesticide factory. However, the leakage was so humongous that it reduced the quality of the air in the city, that causing breathing problems for the people living around in the area. In this case, XYZ will be absolutely liable but not strictly liable. XYZ will not be liable under strict and absolute liability principle because the leakage only killed the pests and insects. XYZ liability under strict and absolute will depend upon the inquiry as to whether the leaked pesticide gas was a hazardous substance activity of chemical or not, and XYZ will be liable under the polluter pays principle. And D says XYZ will not be liable under the polluter pays principle. Okay, so those of you who are confused between option A and option C, here option A is तो बोल रहा है कि will be absolutely liable but not strictly liable. ठीक है, क्यों? Strict liability passage में अगर आप वापस जाओगे, passage is clearly mentioning about, one second, why it's not moving? Okay, anyways, passage is strictly mentioning that in strict liability also you are keeping strict hazardous substance. So option A तो ऐसे ही overrule हो गया ना. Now option C seems to be the most suitable one because आप पहले check करोगे that pesticide is hazardous or not, and whether it has chemical activity they were involved or not. So keeping that in mind, option C seems to be the best one because it is explaining in detail why a person, in this case, what can be the best possible scenario, and keeping that in mind, best possible scenario, option C seems to be the most justified one. नहीं तो अभी तक तो दिल्ली में इतने pollutions हो रहे हैं, and although this doesn't fall under the category of hazardous substance, but since the subtle burning is happening and the pollution AQI is, really bad, not only in Delhi but across India, in major cities like in Mumbai today also AQI was really bad. So there you cannot actually impose the principle of absolute and strict liability. Okay, so this was with respect to this aspect, guys. Now I wanted to cover some of the topics from the current affairs aspect. So first of all, we will pick up the month of September. So September May in next class we'll cover the topics from your the month of other month, like from January till July, and then most probably if there's something in news from October perspective. So in September, the first thing which came into picture was your Nari Shakti Vandan scheme, which was 106th constitutional amendment. So this is not for the first time when the government went ahead with, or we're talking about the empowerment of women. We all know that there are reservations for women in panchayats and municipalities, and that has been implemented through 73rd and 74th constitutional amendment. Then there was another bill which was introduced to reserve the 1/3 seats for women in Lok Sabha and state assemblies. Similar attempts were made at various occasions. In 2008 also attempt was made. Then in 2008, when the bill was introduced in Rajya Sabha, and it was passed also in Rajya Sabha, but later the bill lapsed. Similarly, if you take into consideration, this is not for the first time, there has been many private members also members of parliament introducing a private bill to go ahead with the same, but finally it has got a shape and it has been passed as 106th constitutional amendment. And there are certain articles of the constitution which has been amended. For example, we have article 239A. You need not to remember the article unless and until they ask this question in your GK sections. Then they have also inserted certain articles like 330A, which is, reserving 1/3 seats for women in the House of Lok Sabha. Now, since why you need to remember or focus on article is because CLAT has been asking numbers also in GK section. So from that perspective, you may focus on some of the important aspect. Otherwise, पूरे detail में नहीं जाएंगे. Now, when we talk about this women reservation, so why it was very much needed, because there is an underrepresentation of women in legislature. It is not only in parliament, everywhere there's an underrepresentation. If you guys have been keeping an eye on recent Supreme Court developments and discussions, you must have come across news where there has been lots of discussions with respect to women lawyers condition. Specifically, since Justice Chandrachud has been mentioning this at multiple occasions, where he has been talking about the utility services which is available in the court, the numbers of women who are practicing, what are the circumstances or scenario basically which is hindering the practice of women the role of women in litigation, and also everywhere there is a underrepresentation of women. So that was an area of concern. Then obviously patriarchal nature of political parties. Pehle to pata hi tha na, it was very easy to so they only needed women while doing their elections rallies so that they can attract the voters and voters can cast vote in their favor. But now they also have to field women candidate. And the other thing is there are some other, first let's talk about the need also. Then we have to have a gender sensitization of public policy. And then when we are talking about concern, so concern is against, this is the idea of inequality, you can say. It will also impact voters choice. Then you must have seen in panchayati raj election how things are happening. If I'm not wrong, I mean, if you guys have watched this series called Panchayat, which was, which was released, I think, few years back, the first season of Panchayat, you must have seen that how women was the representative, but the actual action was being taken by a husband, and he was known as Pradhan Pati. And he was the key factor, or you can say key person of contact. So same thing may happen abhi a person, because the seat will be reserved for women, you have to field a women candidate. But यहाँ पे थोड़ा better हो जाएगा, because your husband or your male member would not be accompanying you to Lok Sabha, or for that matter state legislative assembly. So there she may have a little bit of freedom and actually to showcase her talent. So I think to some extent the situation which is there in Panchayat and which is there in Lok Sabha and state legislative assembly, it will be little bit different and it will be a better situation. Then second thing which was there in news with respect to in the month of September was simultaneous elections. Lots of discussion is being taken into consideration to have a simultaneous election. This is something which I would not be discussing, because they are, law commission has recommended, your prime minister has also invoked about this, then Niti Aayog has also discussed about the same, then a law commission's draft report is talking about the same. So basically the idea of having one nation one election is, it will be less time consuming, it will be less there will be less expenditure in comparison to where you are going ahead with separate elections for each and every state. Then obviously there are some other concerns also, because the local people need of people at the state level is different, similarly at the center level is different, so maybe people may get confused. So all these are few issues with respect to simultaneous elections, or you can say one nation one election. Then next thing was with personality right. If I'm not wrong, I think I had discussed this in last class also, because the Anil Kapoor case was there, where the court has clearly stated that personality right refers to the right of a person to protect his her personality under the right to privacy or property. It is significant to protect privacy of individual. It is significant to protect individuals' right to derive economic benefit out of their personality, their traits, and also to prevent consumers from misleading advertisement. Before this also, you guys must have heard about a situation where, okay, so let's take into consideration this example. You must be seeing, you all must be on Instagram, and on Instagram now you see that when a celebrity posts something or when they endorse something, now they're supposed to write it as ad. And where they actually like a product, they clearly says that it is not an ad, because here consumer gets influenced by what is being shown. And especially if their favorite, personality is using that particular product, they tend to use it. So there has been also lots of discussions with respect to whether we can held, other than the company who is manufacturing that product, whether we can held the person liable or not for the, going ahead and doing that advertisement, influencing public to use it. For example, another example of this can be there used to be a beauty cream, Fair and Lovely, which was, now they had to change the name, because the idea and the concept was why you are trying to convey that you will be applying this and you will be, turn into a fairer person. So all these are interrelated. Consumers' perspective, consumers' choice, consumer mind, and misleading thing. All these things are being taken into consideration. So it also has some linkage to personality right. Then when we talked about personality right in India, the court stated that it is, although not mentioned in any statute, there are two components of personality. One is with respect to right to publicity, the other one is with respect to right to privacy. When we talk about right to publicity, so it basically is with respect to right to keep your image and likeness from being commercially exploited without permission or contractual compensation. And it is governed through various acts, for example, Copyright Act. It is also being governed through Trademark Act. So all these are the act which talks about the right to publicity. Then we have right to privacy. Puttaswamy judgment is there. Article 21 of the Constitution says that right not to have one's personality represented publicly without permission of that particular person. So all these are the issues. Then there has been multiple cases. For example, there was a case of Titan Industries, there was a case of Arun Jaitley also, there was a case of Sakshi Malik also, where it was like that you cannot use a image of another person, especially when this is someone's private image. Yes, Sarvagya, this is with reference to Anil Kapoor's case. Yes, Devansh, this is when we are talking about the Puttaswamy judgment and all, the Aadhaar judgment is related. uh Own flaws. Yes, Arya, every amendment has their own flaws. For example, if you go by yesterday only, I hope you guys are reading newspaper. There was an article in yesterday's or day before yesterday's newspaper, I'm not sure where it was, but I think it was by P Chidambaram. Indian Express mein tha, where he was talking about the flaws of the amendment which has been done to Indian Penal Code, where he was talking about nothing new is there in the act. There are certain confusion with respect to certain aspect. And then he was also talking about the name, that how everything inside the act is in English. Aap uska Hindi name de rahe ho, so that is also impacting. So you can read that article also, because it's giving a different perspective and different scenario with respect to amendment. Okay, yes. So this was another news. Then the third was with respect to, you all can also focus on the, new secretariat of parliament has been made, and also wo bhi ek baar dekh lena. Then third thing which I wanted to discuss was with respect to prison reforms has been there. So Parliament Committee has submitted reports on prisons conditions, infrastructure, then reforms are there. Intention is correct, Arya. That is a different topic. I will not get into the political aspect of that particular thing, but yeah, so see, it is also going to, if you're not giving anything new to the act, just making or reshuffling the section. So although your intention may be wrong, but the idea with respect to your Indian Penal Code, or for that matter entire criminal manual, is this is British era law. So if you want to get out of that colonial pictures of that particular act, you actually have to add something which is with respect to current scenario also. And that is there, so which is missing. But although, yeah, obviously the entire act is not wrong, but it will be a big problem with for the lawyers and judges also. Lawyers have to remember now new sections when they have to argue, although this has not become an act, so still we are governed with respect to original one. Could we get separate videos on legal updates? I'll try to record. Okay, the next thing was, I think in last class also I had mentioned about disqualifications of lawmaker. So other than Rahul Gandhi's incident, recently Karnataka High Court had also disqualified one of the member from one member of Lok Sabha from one constituency as void, and the decision of disqualification was made on grounds of guilty corrupt practices, which includes wrong disclosure of values of properties, which also includes evading of taxes. So when you go on contest for an elections, you are basically supposed to disclose whatever assets are there, and basically you're supposed to disclose all the truth with respect to you. But if you have misleaded the public, or for that matter if you have done a wrong disclosure, so on such ground also it can be disqualified. And there are three acts which, or three situations which actually deals with this. The one is RPA, Representation of People's Act 1951, which says that a lawmaker can be disqualified for the period of imprisonment and for the 6 year if he is convicted and sentenced to imprisonment for 2 years or more. Then we have 10th schedule of the Constitution, which actually provides for the disqualification on the ground of defection, which we also call as anti-defection law. And then we also have Article 102 Clause 1 and 191 Clause 1, which talks about disqualification of a member of parliament and member of legislative assembly. So the ground here, including holding an office of profit, being of unsound mind, insolvency, or for that matter, not having valid citizens. So these are the grounds on which a members can be disqualified. Why I'm discussing this? Because other than Rahul Gandhi's case, this was also very important. Okay, now let me read the chat box. Okay. Sarvagya, I'll pick this in next class. I'm going to pick this matter. Kaveri water dispute wala. Okay. Also, there was a question by a person that I am lagging in, current affairs. क्या करना चाहिए? पहले तो जितने mocks हैं उन सबको लिख लो, current affairs वहां से revise कर लो, because whatever is the important topics has been covered in that particular mocks. Next is you can pick any one of the sources. For example, Manthan 2.0 are there. So you can also, from Manthan 2.0, you can revise all the current affairs from your examination perspective, because this is the time where you actually have to revise things. Now you cannot go back and read something new. So whichever one source is there with which you are very much comfortable, pick that source up and then revise it from there. Okay, then next last topic which I'll discuss for today is Digital Protection Personal Data Protection Act, Protection Act of 2023. So we all know that the president has recently granted assent to the Digital Personal Data Protection Bill 2023. Puttaswamy judgment, Supreme Court has upheld the right to privacy. Then there was Justice Sri Krishna Committee, which was established by MITI, which proposed the initial draft of Personal Data Protection Bill in 2018. Then recently government has to withdraw the bill because there were so many changes which was made. The actual crux or the actual idea behind that particular bill was taken away with so many changes. There was also changes by joint committee of parliament to it. So keeping that in mind, they rolled it back and then they released a draft in 2022 for public consultation, and which later became the DPDP Act 2023. Yes. So it basically aims to regulate the processing of digital personal data while ensuring individuals' right to protect their data and the need to process it for lawful purposes. It protects digital personal data. It also talks about the obligation of data fiduciaries. It is also talking about the rights and duties of data as principle. Then it is also talking about the financial penalties which can be imposed when there's a breach of right, duties, and obligation. So these are few aspects with respect to data protection bill. So I think you can also go ahead and have a little bit look about GDPR, General Data Protection Regulation, and the act, which is the recent act, where it is now saying that children under the age of 18 needs consent from parents and guardian. All these are things which you need to go through. Then also you may have a look on reforming India's criminal laws, which was introduced recently, and you can also, so you have to read from both the perspective, where one is supporting, the other one is criticizing it. And then I think for these were few things which was important from the month of August and September. I'll pick up next May. I'll pick up the Kaveri issues. We'll pick up the issues from October perspective, and also we'll pick up some of the judgments of Supreme Court, which is really great and which we can expect and examine from examination perspective. No, I'm not using any PPT area. Okay, so these were from today's class, guys. I hope this class was of some help. In next class also, would you like to discuss 2-3 passages, or directly we shall go ahead and cover current affairs? Just let me know, guys. I'll wait for your response in the chat box. I'm waiting for your response. Will CL release a compendium? Yes, it will be done. Oh, with respect to legal, I think you are already getting legal updates in your aspiration, na? Okay, so some of you are saying passages also. So maybe we'll pick one passage and then one or two passages, and then we'll cover, current affairs also. Okay, some of the questions also followed by current affairs. Okay, we'll do that also. So maybe next class we'll extend it little bit more than maybe we'll take 1 point, मतलब 1.5 घंटे की class will take that. Okay. Okay. Thank you guys. See you in the next class. I had to look in my phone also for what you guys are typing. Okay, thank you so much, guys. We'll see you in the next class.